the school cases were the culmination of a series of cases, starting with juries, voting, and then the higher education cases, the graduate school cases, and then the college cases, and finally, shoot the works, and that was Brown, that was public schools. And the 5 cases that were started were carefully selected to present every variety of school districting and school district problems that there could be. I don't remember the details of it now, but I know that there was a reason that Clarendon County, Virginia was chosen. I know there was a reason that Topeka, Kansas was chosen. I think in some you had elected school boards, and some you had appointed school boards, and some you had multi-district schools, and some you had a unit district school. I mean, those cases were put together for a reason. And the D.C. case was added to cover the Fifth Amendment part of it and to ensure that the law, whichever way it went, would be the same under the 14th Amendment as applied to the states as it was under the Fifth Amendment as applied to the federal government and the District of Columbia. So
of course, everyone thinks of the Brown case. Undoubtedly, one of the 2 or 3 most important cases ever to be decided by the Supreme Court in the field of race relations. And some individuals, particularly the younger generation, almost seem to suggest that the Civil Rights Revolution started with Brown, and that is a deceptive inquiry. It's somewhat like watching the Mets win the World Series, as if one believes that the last game of the World Series was the beginning. And what we know is that whether you're talking about the Super Bowl or the World Series, there were years of preparation and training which made the 9th inning possible or the 4th quarter victory possible. And without those key movements, those key quarters, those key earlier innings, the 9th inning would not have taken place, or the last quarter would not have taken place. Now, what were the earlier quarters in the civil rights struggle in the higher education field? The major case before the Supreme Court, the direct assault originally, was a case called Gaines v. Missouri. And in that case, Gaines was a citizen of Missouri. And he had the temerity to believe that since the state had only one law school, that he should be able to attend it. But the Missouri Supreme Court, tragically, in a unanimous opinion, that state court said, that since there were schools available in Nebraska and in Illinois and in Iowa, which would accept blacks, that Gaines would have to go to one of the schools bordering Missouri rather than to go into his own native land. The tragedy of it was that Missouri accepted students from out of state. I think the record indicates that maybe about 20% of the students were from out of state. But Missouri was saying a black had no right to go to school in his own state. And the United States Supreme Court heard that argument, and by a magnificent opinion by Chief Justice Hughes, they held that that was a violation of the Equal Protection Clause. That even if a state was going to provide separate education, it couldn't provide separate education outside of the state. And that was one of the first major breaks in the system. The second major break would be Sweatt v. Painter. Sweatt v. Painter was argued before the United States Supreme Court in the spring of 1950. Heman Sweatt was his name. He was a courageous black veteran from Texas who felt that he should be permitted to go to the best state law school where he paid taxes in that state. So he applied to the University of Texas and was denied admission solely because of his race. And what occurred in Sweatt v. Painter was that they then built a completely separate law school for this one black. And the issue became whether that was a violation of his Equal Protection Clause. The United States Supreme Court, in a unanimous opinion, held that the denial of admission to Sweatt was a violation of his 14th Amendment rights. Because they went on and they said, what makes a great law school? It's not merely a building. It's not merely a teacher. It includes its history, its alumni, its heritage, and that a school could never be equal, which has just been created with no heritage, no alumni. Obviously, they didn't have the equivalent in books and professors. So that was a message to the state now that in the state you cannot have separate facilities which are grossly unequal. And in effect, it said that for certain types of training, professional training such as law, there can never be the equivalent of a school which has been in for 50, 60, 70 years as a great law school. You can't put up a one-room, two-room, three-room law school and say that that is equal protection of the law. The third fascinating case is a case called McLaurin v. Oklahoma. McLaurin was a distinguished gentleman, probably 60 years or older, from Oklahoma. He had taught in a black college, and he wanted to get his PhD. Well, Oklahoma apparently doesn't have as much money as Texas, and they weren't about to put up a complete new school of education for one black to get his PhD. So what they did was that they admitted him, but segregated him and required him to sit in the hall while the other students were in the classroom, or in some instances segregated him within the library. And the United States Supreme Court held, and McLaurin, that in graduate school education, this segregation, which precludes the association of students, when imposed by the state, is a violation of the Equal Protection Clause. So those were the two very, very major cases, plus Gaines, which were the beginning of the assault before the Supreme Court that led up to the Brown case. I guess it all goes back to the Harlan's dissent and the Plessy v. Ferguson, where he talks about a colorblind society. And that articulation that the state cannot use its momentous power to discriminate on the basis of race was a powerful idea. It was an idea whose time had not come, but it did ultimately. And as you read through the opinions, you see increasingly some state court cases and some federal cases where, particularly in the middle 20th century, where the courts are looking with increasing suspicion in terms of discrimination on the basis of race. You see it in issues involving housing, in cases such as Shelley v. Kramer, which came down in the 1940s. You see it in cases which involve discrimination in primary elections, and Smith v. Allwright. And when you start putting the voting cases together, which say you can't discriminate at primaries, and when you start putting the housing cases together, which say that you can't enforce restrictive covenants, and when you start putting together the transportation cases, such as Morgan v. Virginia, which said you can't discriminate in interstate commerce, it is that cumulative expression that this American society must ultimately be based on some egalitarian concept, and that race is not a legitimate factor which may be used for adverse discrimination.
Now, all these cases that you mentioned were before the 1954 Brown decision.
That's right. They all were before the Brown case. And those were the early innings before the ninth inning of the World Series. Now, lots of people are going to debate. They will say that the World Series has not been won, and that after Brown, we're still only at the first or second. And I wouldn't argue that. But in terms of the whole Brown doctrine, there were 8 earlier innings.
In terms
There was an overall strategy. It wasn't a haphazard aspect. They recognized that they had Plessy v. Ferguson on the book, a case decided by the United States Supreme Court in 1896, which said that a state could have separate facilities under what they called a separate but equal. But as Attorney Hill has demonstrated, it was almost never equal. And his community, they didn't have high schools. And thousands and hundreds of thousands of blacks were denied an adequate education. They got the separateness, but never the equal. So what I want to do is to explore a bit, with my good friend Oliver Hill, is what was the strategy? You said that the first cases were in the teacher's salary range. I want you to tell us why you started on teacher salaries, what was your overall plan, and what were the other items on your later agenda?
Well, the overall plan, of course, was to obtain complete equality of educational opportunities for blacks, along with other segments of the community, and to assure that blacks receive the same compensation for their endeavors. But we recognize the fact that we might not be able to jump the whole hurdle at one time, and we were willing to challenge it under the prevailing law. With the idea, you see, it was separate but equal. We recognize that if they provided equal opportunities, educational opportunities for blacks, sure, Negroes, we used to call ourselves in those days, the separate business would break down of its own weight from an economic point of view.
What do you mean by that?
Well, it wouldn't take them long to recognize the fact that this dual school system on an equal basis was just too expensive. Mm-hmm. When they could do it all on a unified single basis, unitary basis. So.
What the court actually said was that the states were to admit to public schools with all deliberate speed on a racially integrated basis the parties to these cases. But the lower courts allowed that to be, the word deliberate speed to be picked out of its context and translated to mean forever. That's what it seemed to me. But I used to argue that what the court had written was to admit to public schools on a racially non-segregated basis with all deliberate speed the parties to these cases, not the grandchildren of the parties to these cases.
We're talking about the big mistake in the Brown decision is that when the Supreme Court decided the case in 1954, it didn't say do it now. And for 10 years, I had argued before courts there's no kindness to cut off the tail of a dog an inch at a time. The only way to cut that tail off is get up and cut it off. It's all got to come off. But it took us 10 or more years to get courts to see that. During that time, the realization came to me that, and nobody's shown me yet that I was wrong, that NAACP had not prepared for Victor and Brown. Now, I might be wrong in that. That 1 year gave the reactionary forces time to seize the initiative. because we went through, and here in Virginia we certainly went through, in the period of massive resistance, a period when we were reacting to what the reactionary forces were bringing, whereas before then they were reacting to our lawsuits. And it is a whole lot more. We are a whole lot more comfortable when we're in a position that we have the offensive, and the other side has to react to us, and when we have to be fighting off, warding off the blows that they're throwing toward us.
Now, after the Supreme Court's decision in the Brown case, as I told you, there was unexpectedly, from our point of view, this grassroots revolution, which changed the whole course of our strategy. We had intended, after the Brown decision, to use all of our resources, manpower and financial resources, in implementing the Brown decision. And we had many meetings, of course, strategy meetings, which resulted in a determination that we would move first in the border states like Kentucky and Tennessee and Maryland, where we expected resistance to the Brown decision to be less. But we were not able to use all of our resources in that regard because, as I've said, these grassroots revolts, like the students and the Rosa Parks, required that we divert some of our time and energy to defending them and upholding their rights. The other thing which claimed our attention and our time and our energy was combating activity on the part of state governments, which sought to block implementation of the Brown decision. The states, many of the southern states, enacted laws which were designed to cripple us, to frighten lawyers into refusing to associate with us for fear of losing their licenses to practice in the state. The organization itself was subject to suit in many places. The NAACP was subject to suit in Alabama. The organization was closed down in 1956. There was a suit in the state of Virginia, which we brought to try to get these state laws aimed at curbing our activities as a legal aid society declared unconstitutional. I remember going to Arkansas once, about 56 or 58, when there was a suit brought against the Legal Defense Fund, claiming that we had failed to pay corporation taxes or something of that kind. The NAACP there was sued for failure to give up its membership list, as had happened in Birmingham, so that we were spread so thin that there were many times when we felt that we just could not carry on. At the same time, we were trying to carry on our established program of trying to dismantle segregation in education. But this was the beginning of the Southern strategy to defeat civil rights activity in the court, and that is to use technical objections and technicalities, legal technicalities, to thwart the action. And so we experienced that throughout most of our legal activity, particularly after the Brown decision, when the Supreme Court said segregation is unconstitutional. Well, the Southern lawyers could not go in court, who were representing school boards, and argue segregation is constitutional. That was settled. The only thing they could do was to try to delay as long as possible the progress of the case. And so they used one legal stratagem after the other. And it took 2 or 3 years sometimes of just meeting these technicalities in the federal courts before we could even get to the merits of the case, and that is whether the school board ought to come forward with a plan to desegregate. Now, some of those cases are still going on 30 years later. I think the one in Savannah is still going on, the one in Memphis, Tennessee, the one in Atlanta that I tried, and so forth. They've been revived. At times they died down and then they're revived again. But the long and short of it is that the implementation of Brown has now taken 30 years. And in many places, of course, it is still not fully implemented. And there have been all kinds of changes.
Well, the Constitution, from a racial standpoint, can be looked at in a bifurcated fashion. When it was passed in that marvelous building in back of us, where the forefathers met in 1787, the Constitution, in a real sense, had no relevance at all to blacks in terms of the words of the preamble. The preamble speaks of a more perfect union. It speaks of liberty and justice, none of which it provided, because the Constitution was passed and included in provisions such as Article 1, Section 9 for the migration and importation of slaves, the 3/5 clause in Article 1, the fugitive slave clause in Article 4. All of these were passed and incorporated in this important document, not to give blacks freedom, but to ensure the capacity of those in power to enslave them. That is the reason why you have this tremendous dialogue. William Lloyd Garrison, when he published The Liberators, called the United States Constitution a compact with hell and a covenant with death. And that is, in a strange way, what it was from a race relations standpoint in 1787. And when did it turn around? It didn't turn around in the 1850s because Chief Justice Roger Brooke Taney, writing for the majority of the Supreme Court, said under the Declaration of Independence and the Constitution, and these are his words verbatim, blacks have no rights which the whites are bound to respect. So that the first glimmer of hope from a constitutional standpoint takes place in December of 1865, when the 13th Amendment was ratified. And as you know, that was the amendment which abolished involuntary servitude, abolished slavery. The next significant glimmer from a constitutional standpoint was the 14th Amendment, where it has these key provisions on due process, privileges and immunities, and equal protection. And it says in the very, very first sentence that all persons born in the United States are citizens of the United States. And that was passed to overrule the Dred Scott case. And the second great glimmer, where blacks were going to be incorporated into the American mainstream, was with the 15th Amendment, and that was passed in 1870. So those are the critical dates. So that for blacks, the Constitution, from a race relations standpoint, has a profound vitality from the 13th, 14th, and 15th Amendment. Now, by that, I'm not suggesting that the other amendments are unimportant. Obviously, what Madison did on the Bill of Rights inures to everyone, and to blacks as well. But those amendments had no impact whatsoever on blacks from a federal constitutional standpoint until 1865 at the earliest.
This country is a very strong and powerful country. We probably have more assets. We're better situated. You name anything, we have the advantage. But the most important thing is we have that it's a group of free people that are trying to determine their own destiny. And it's very important that each generation realizes that the generation before them had many problems, some of which we solved, some of which we didn't, and we left on to the future generation. But that basically the men and women that will be remembered are those that made great contributions to try to right the wrongs that they found in the society when they took control of it.